Hello, everybody. It's nice to have you here. This is Cathy Lucrezi. I'm a supervising attorney at Legal Aid Service of Collier County. And you're tuning in to our Lunch and Learn series on proving your Social Security disability claim. In an earlier Lunch and Learn session that we did about 2 months ago, we talked about the difference between SSI and what's called SSDI, or Title II disability. Today, we're going to talk about what it's like to apply for the disability benefits and what that whole process looks like and what you can do to make your claim the very strongest it can be. Of course, step one to starting a claim for disability benefits is you have to apply. You can apply for disability benefits by going online to the website for Social Security Administration, or you can call Social Security, the number's online, and tell them you want to make an application. You can also go in person to the Social Security office and make your application there. Now, because of COVID-19 restrictions, the in-person option is not available to you for now until everything reopens. So to apply, you need to either go online or else call Social Security. Now, when you call Social Security or go online to make your application, you need to have some information ready to give to the agency. Of course, your name, your date of birth, your address, all that sort of thing. They'll ask questions about your marital status. Not only are you married now, but have you ever been married in the past? And how did those marriages end? They'll ask for the names and dates of birth of all your children, perhaps even children that may be deceased. They will ask whether you're working, when did you last work? They will ask how far you went in school, whether you went to college or got any special training for any special trade. And then they'll ask you, what is your disabling condition? And here you want to be thorough, but you want to be sure that you don't exaggerate. You want to list every medical condition for which you've seen a doctor. And by medical condition, I include things like mental impairments, depression, anything that you go to see a healthcare provider for. So you might say, well, my disabling condition is that I have loss of vision in both eyes. Fine, you're going to tell that to Social Security. But if you also have other medical conditions, you want to tell that too. You might say, my disabling condition is a loss of vision, but I also have diabetes, and I've got pain in my right knee, and I've got arthritis in my shoulder. You want to give a complete list. The agency might ask you for the names of your doctors, and so you should have those ready. Now, once Social Security gets all this information, they review the claim and decide whether you're eligible for benefits. At this first stage, it's very common to have your claim denied. If that happens, don't be discouraged. You can ask for a reconsideration, but there is a deadline for the reconsideration. The deadline is 60 days from when you got the notice that your claim was denied. Pay attention to that deadline. You don't want to miss it. When you get the letter that says, hey, we turned down your claim because we don't think you're disabled, it will tell you you've got 60 days to ask for a reconsideration. Do it. Quicker, the better. The way that you ask for a reconsideration is you can go online and get a form asking for a reconsideration, or you can call Social Security and tell them you want a reconsideration, or you can go in person. But it's just like the application. Right now, the offices are closed to the public, so you're probably going to do it over the phone. That's the most common way right now. When you ask for the reconsideration, the agency will ask you, well, why do you think we got it wrong? And you can say, well, because you know, I have this new doctor, you didn't get to look at his medical records, or you didn't consider this, or I think you need to look at it again. Anything like that is okay. All right. Now, at the reconsideration stage, somebody else at Social Security looks at your file, and that person makes a decision. Did we get it right the first time around, or are we wrong? Is the person disabled or not disabled? Often, claims still get denied at this reconsideration stage. And again, don't be discouraged. If you get a notice that says, we reconsidered the decision we made and you're not disabled, we're not going to give you benefits. That notice is going to say you can appeal that decision, but you have to do so within 60 days. Again, that's a deadline you've got to meet. Don't wait. All right. The letter will tell you how you can ask for this next stage of an appeal process. The next stage is called a request for a hearing before an administrative law judge. And this is when you'll get to have the chance to really present your case in the best light possible. The request for a hearing is done just like the request for reconsideration. You can do it online, get the form, you can call Social Security, or if we ever reopen the world, you can go in person to the Social Security office. Again, the deadline for doing that is 60 days after you got the notice of the denial at reconsideration. Now, once you make that request for a hearing before the administrative law judge, a lot of things start to go into motion. And as I talk about this next part, I'm going to start referring to the administrative law judge as the ALJ. ALJ. The ALJ is not at the local Social Security office. In fact, the ALJ who gets assigned to your case could be anywhere in the United States, because the trend right now is that hearings are done by video. So for instance, I have a hearing coming up and the judge who's hearing our case is in Knoxville, Tennessee. Yet myself and my client are here in Naples. So anyway, your case gets assigned to an administrative law judge. And Social Security will start sending you lots and lots of forms for you to fill out. They will send you something called a disability report. They will send you a form where you list all of your medications. They will send you a form to list all your doctors, all that sort of stuff. And I got to say, this is going to be the first of many packets of information that they send to you to fill out and return. And you'll think to yourself, I already did this. I did this once. I did this twice. If they send it to you, you want to pay attention to it. Okay. And that's because it can take a long time for this whole process to work. And so whatever you might have sent them back in September of 2020, a lot can change between then and now, March 2021. So they're asking for an update on information. One of the papers that they'll send you is whether you agree to have your hearing done by video. My suggestion is you should agree. And a couple of reasons for that. One is, if you say that you really want to have an in-person hearing, you might be waiting a year before that hearing ever gets scheduled, because we don't know what COVID-19 might bring around. Also, if you say that, yes, I'll do a video hearing, it's easier for Social Security to schedule that hearing, and that works to your advantage because it means it might be sooner than if you wanted to do it some other way. Some hearings are done only by telephone. That's okay, but quite frankly, it is better, in my opinion, to do it by video. So if you get one in all those papers that Social Security sends you, if you get one that says, do you object to a video hearing, I recommend that you say, nope, I agree. I'd love to go to a video hearing, okay? Now, in addition to Social Security gathering all the information about you, they are going to, they may ask you, they don't have to, they may ask you for to go to a consultative exam. And that's where you ask, or excuse me, that's where Social Security asks you to go to one of the doctors they hire, so that doctor can test you and give an opinion about your medical condition. Sometimes that letter comes from, it's the Department of Disability Determinations, and it's from Tallahassee. So it might not look like the other Social Security letters that you get. But if you get one, it'll say something like, hey, you've got an appointment on Wednesday, May 15th at 10 o'clock with Dr. Joe Schmo, and you got to be there. Show up to that appointment. The doctor's not going to give you treatment. He's going to be testing you, okay? So be sure you keep that appointment. Don't miss it. What you can be doing during this time is gathering any new medical evidence. Remember, Social Security is going to make its decision based on the evidence that it has. And for medical evidence, they want to see reports from healthcare providers. It's great and it's important that you, and you will get a chance to tell what things are like for you on a day-to-day basis, but they need the medical evidence. And so if you started this whole process back in September 2020, and since then you've been to the doctor several times, you want to make sure that all of those new records get into the Social Security file. You can gather them together and submit them to Social Security. Again, they're going to send you papers and say, hey, you got to sign this, send it back, do it, do it, do it. Be sure you understand what you're signing, of course. One of the things, it's at this stage where you could actually do it earlier, but this is a good stage for you to decide, should I get somebody to help me with my case? If you've got the right to go to the hearing by yourself, or to have some qualified adult with you at the hearing, or to have an attorney. You don't have to have an attorney, but there's advantages to having an attorney. An attorney can be sure that the record has all of your current medical evidence. The attorney knows the process, is more familiar with the lingo and how things go through the system, and that can be a big help. If you hire a private attorney, the private attorney would be entitled to collect his or her fee, from what you might win from Social Security. So there's a lot, and you probably have seen commercials on TV that attorneys love these cases because if it's a good case, they know they can make some money off of it, and they're experts at what they do. At Legal Aid, we take on a case, but we don't collect the fees from whatever you might win. So it's your choice: private attorney, legal aid, some friend or relative, or do it on your own. I really recommend that you get somebody who's experienced at doing Social Security hearings to help you with this process. The timing of it is important. You can hire an attorney or a representative at any time. But my preference is that people would come to me right at the same time that they are requesting a hearing before the administrative law judge, because I know that gives me enough time to get ready for a hearing, to do what I need to do to write a brief that describes why you're entitled to benefits. It's also a time when I think the most efficient way for the representative to work on the case, to have some impact on it. You can hire an attorney earlier in the process, but again, my preference is to get into the case right now. The key thing here, though, is do not wait if you're going to hire an attorney, do not wait until you get, the day before the hearing. Nobody's going to represent you if you wait that long. If you're requesting a hearing before the administrative law judge, get a hold of who's going to help you with this case. Get a hold of the person who's going to be your representative. Do it right then. It takes Security a long time to set these hearings. It can take months. Once the hearing is set, you will get a notice of hearing, and the notice will come at least 75 days before the date of the hearing. That's a lot of time, but still, you want to have your representative busy well before then. It takes a lot of time to put together the case. When they send you this notice of hearing, this is another big pile of paper that Social Security sends to you. Some of the things will ask you to sign and send back. There's one that's very important, and it's called an acknowledgement of the notice of hearing. They want you to sign that and send it back so they have proof that you know when the hearing is going to take place. Again, if you're not sure what you're signing, you want to get somebody to help you understand it before you sign it. Most important, whatever date and time the hearing is, put it on your calendar. You do not want to miss this. This process of going through Social Security takes a very, very long time. And so you don't want to miss your chance of having the hearing before the ALJ, because you could be waiting a much longer period of time. So let's say that you've got your notice of hearing, you're all set to go. You've got a representative. The representative has made sure that everything that could possibly be put into the record has been placed into the record, and you're ready to go. Now, if you're doing a hearing in person, which again, the hearing offices are closed because of COVID. If you happen to get lucky enough to have an in-person hearing, you want to be sure you wear comfortable clothes. Sometimes the hearing rooms are very cold, so you want to be able to adjust. Do not bring little children with you unless you have somebody who can sit with them outside the hearing room, all right? Put that aside, because really what's going to happen is you're going to have a video hearing. And for a video hearing, you need to be sure, well, and this is true for a telephone hearing too. Video or telephone hearing, you want to be in a quiet place. No distractions. No kids asking you, when's lunch ready? No dogs barking in the background. You want to have a nice quiet place where you could be on the line for maybe an hour. So be sure you plan to be in a good place for that. Be sure whatever device you're using is charged up. You don't want your battery to die in the middle of your hearing. You want to test all of this if you need to before the time of the hearing. The most important thing though, be on time. If it says that your hearing starts at 11:15, then you be ready at 11. I mean, there is nothing that judges hate more than somebody who is late to their own hearing. Be on time. Now, what often happens with the video hearings, it happens in all kinds of proceedings before judges. It's not just Social Security. Things run late. So if the hearing ahead of you runs late, your hearing might not start on time. So let's say that your hearing is supposed to start at 11:15, and your representative told you you'd be ready at 11, and it gets to be 11:30 and nobody has contacted you, or it's gotten to 12 and it's still. Stay ready, because it could just be that they're running late and they will get to you when they get to you. Now, usually somebody calls your representative and says, hey, we're running late. We expect to start up. That can happen. But unless you get word that, we're done, it's not going to happen, you stay ready for that hearing. Don't miss it. So let's talk now about what happens at the hearing. At the hearing, it's not quite like a court hearing. The ALJ is there. There's also a clerk. That's somebody who works for the judge and who makes sure that they are recording everything and have all the papers in order. It's going to be you, your representative, and usually a vocational expert. And I'll tell you more about that in just a second. Those are the people that will be in the hearing. You're not allowed to record the hearing or have or tape it onto your phone or anything like that. You're going to be in the hearing just for those people. You, your representative, the ALJ, the clerk, and the expert. The judge will place you and the expert under oath. And this is just like on TV. You swear to tell the truth, the whole truth, and nothing but the truth. And then you'll be asked a lot of questions. The questions can be made by the judge or by your representative. And they will ask a lot of questions. It could be, what do you do all day? How do you pass your time during the day? Do you have hobbies? What was the last work that you did? And what was it like? Did you supervise people? How much can you lift? How much can you carry? How far can you walk without difficulty? Now, I don't know if you're like me, but if somebody says, can you lift 10 pounds? I don't really know. But think of it like groceries. Can you lift a gallon of milk? Can you do that repeatedly without pain? Are you able to walk to your mailbox, which is 50 feet from your door? Can you do that without pain? Can you do that without assistance? Do you need a cane? Are you able to drive? And if you don't drive, why not? Is it just because you don't want to or because you can't? They'll ask questions about your social activities. Are you a part of a club or an association or a church? And it sounds like they're prying into private life, but what they're trying to get a sense of is how well you are getting on in life. And that includes your social activities. You'll be asked if you have any side effects to the medicines that you take. For some medical conditions, you might take painkillers that make you sleepy or they make you dizzy. So even though it might get rid of the pain, it doesn't make you able to work because you're sleepy or dizzy. So the questions can go in a whole lot of different directions. Just be ready for all of that. As a general rule, when answering these questions, I have to stress, don't embellish. Don't be like my Uncle Freddie. If you said, well, how you feeling? Oh, my back, it's terrible. I can't move. I can't, whatever, which, yeah, he had a bad back, but he could move. He drove his car every day and all that. Don't exaggerate. Don't embellish. Be truthful. Be absolutely truthful, but don't make something bigger than what it is. Sometimes we have a tendency when we talk about our medical conditions to make them seem really, really bad. We don't want to do that. Or you might be one of those people that doesn't like to complain, and so you kind of keep it all in. This is not a time to do that either. I've had a client in the past who, if you asked her, how she was doing, oh, I'm fine. But then as you talk more to her, she's also taking lots of pain medicine because she can barely move, and she tells you that she can't get out of bed in the morning until, she has kind of flexed her legs and all that. She was in terrible pain, but she wasn't a complainer. So had to instruct her to be forthcoming and explain what this was like, because if she's saying, oh, I'm okay, then the judge is going to believe her. So you want to be truthful. Don't exaggerate and don't understate what your situation is. At the end of the hearing, the judge will not give you a decision. Instead, he might say he's taking it under advisement. That means that he's taking all of the evidence that's in the record, and he will make his decision sometime later. Don't be worried that you don't know. It's very tempting to try to guess at what the judge is going to ultimately decide, but really only the judge makes that decision. Let me back up a little bit to the hearing and talk about this vocational expert. The reason they have a vocational expert at the hearing is because that's a person who can tell the judge whether, in his or her opinion, there is any work out in the world that you can do. So if the judge determines that, given your education, given the fact that you can lift things of 10 pounds or less, and given the fact that you have good skills, is there any job, Mr. Expert, that this person can do? And the expert will say yes or no, and they'll list various jobs that they say are available out in the economy. This is a very tricky part of the hearing. The judge will ask if you have questions of the expert, but I gotta say, unless you are trained to question the expert, it's usually futile. There's a real skill to asking questions of the expert. And again, this is where it comes in handy to have a lawyer with you at the hearing who at least knows what to listen for, what the expert is saying, and how to ask that expert witness a cross-examination question. Sometimes there's other experts that appear at the hearing. It might be a medical expert. It could be an expert with a particular type of work, whatever. That's up to Social Security. You don't pay for that. Social Security does. Okay. I know I'm doing all this presentation in English, but if you or someone you know is going through this process and speaks another language, Social Security is obligated to provide you with a translator for the hearing, no cost to you. It's good to let them know that they usually already have figured this out by this point, but it's good to let them know that, hey, this hearing that's coming up on June 15th, I need to have a Spanish translator, or I need to have a Creole translator. They will arrange for that. I did a hearing where my client spoke a special dialect of a Mexican native tribe. It was very difficult for them to find a translator, but they got a translator. So you have the right to all of that. And then the really hard part comes, and that is waiting. The time between your hearing and when the judge issues his or her decision can be a long time. It could be quick. It could be like within 3 to 4 weeks, or it could be 10 months later. It's not supposed to be 10 months later, but it's a very slow process, and it's very difficult to wait that time. In some very, very rare situations, your representative can ask for an expedited decision, actually anywhere along in the process, but that's in very rare situations. Usually it's situations where death is imminent, okay? The wait is just really is terrible to wait through, but supposedly it doesn't hurt you, because if you are found entitled to benefits, you'll get paid for all the months that you should have been receiving. So whether the judge decides your case within 1 month or 10 months, if he finds that you are entitled to benefits, you'll get benefits for all of those months. But that's a subject for a different day, because that gets complicated, how they figure out how much you get. In any case, the judge's decision ultimately gets mailed to you. And this is a bunch of papers that it's usually about 20 pages long, because there's a very long part that the judge writes about how he reached his decision. And there's a list of all of the evidence that he considered. I gotta tell you, it's a hard thing to read, but the good thing is that you know whether you won or lost by looking at the first page, because right at the title, it'll say notice of decision, fully favorable, or notice of decision, unfavorable. So you will know right on the first page whether you've won or lost. If you've lost, you still have 2 more appeal levels that you can go. but we're not going to cover those today. But if you get an unfavorable decision from the ALJ, you have 60 days to make an appeal to what's called the Appeals Council. And again, I'm not going to go into that today. That's a subject for another day, but that deadline is there, 60 days. The letter that you get from the ALJ will tell you how you go about doing that stage of an appeal. If you have received a favorable decision, then you'll be contacted by Social Security and they will ask a bunch of questions about your financial situation. This is especially true for people who are going to get SSI. For SSI, they want to know who's in your household, how much do they make, what do you pay in rent, do you own property somewhere, all that sort of stuff. They will ask a bunch of questions like that. Ultimately, Social Security will send you a letter that says, hey, we figured out that you're entitled to this much money. We're going to pay it to you on this date. And usually, I say usually because there's lots of variations that can happen. Usually you get word that you are entitled to a back pay award of a certain amount, and then a monthly amount going forward. So it might say something like, based on the decision of the ALJ, we've decided that you're going to get a back pay award of $2,300. We're going to place that into your bank account on July 3rd. After that, you will receive a monthly benefit of $782 on the 3rd of every month. So you'll get some letters like that. That's how you prove a case in Social Security. The most important things I want you to take away from this session is, one, read the things that Social Security sends to you. They're very tedious to go through and all of that, but there's often information about deadlines. And this brings me to the second thing: follow the deadlines. Don't miss a deadline. If you're a person that doesn't read well, or you're helping a person who doesn't have English as a first language, it still needs to be read. Don't wait. There are time deadlines on these documents, and you do not want to miss them. The third thing is, I think it's excellent if you have a representative help you, whether it's a private attorney or legal aid or some other qualified person. It's good to have someone help you get through this process. It's a difficult process. It's a very long process, and you need somebody to be in your corner helping you out with it. I wish I could take questions. I'm Cathy Lucrezi. I am supervising attorney at Legal Aid Service of Collier County. This session today has been Lunch and Learn, and we've recorded it, so it will be available on our social media. We appreciate being part of this community. We appreciate being able to present these materials, and we hope that you get the legal help that you need. Thank you very much.